Hello and welcome to another Help for Homeowners webinar session. I am Clemente Mejia and I supervise the Foreclosure Prevention Program at the Department of Consumer and Business Affairs. This week we'll be discussing the various moratoria on foreclosure and evictions. In a few days, it'll be the one-year anniversary of President Trump's Coronavirus Aid, Relief, and Economic Security Act, commonly known as the CARES Act. Among other protections, the CARES Act banned the initiation or completion of a foreclosure and evictions for a period of 60 days. Furthermore, the Act allowed property owners with a federally backed loan to forbear payments for up to 180 days, with an option to extend for an additional 180 days. Loans in forbearance peaked in June 2020 with 3.9 million homeowners having been able to suspend mortgage payments. Currently, there are over 2 million homeowners on a forbearance plan. Since the termination of the CARES Act, the federal agencies continue to extend their moratorium on foreclosures and evictions, and these protections are set to expire on June 30th. Homeowners who currently have a forbearance plan will continue to forbear payments until the end of their term, and some may be able to extend the forbearance period for a total of 18 months. However, others may not be afforded an extension, and they will have to work with their lender on a repayment plan or potentially modify their loan. Navigating the process during a time of crisis may be a daunting task. And today we have two experts who will tell us more about the foreclosure and eviction moratorium and where homeowners can get free, reliable help. Sam?
Hello, Clemente. Thank you. Concerning the Department of Consumer and Business Affairs, we're a county department for the County of Los Angeles that aims to benefit or serve consumers, businesses, and other communities through education, advocacy, and complaint resolution. Our mission is to create a fair and vibrant marketplace for consumers and businesses through most of the units that we have listed here: consumer protection, small claims and mediation, the Office of Small Business, Rent Stabilization, Stay Housed LA County, the Center for Financial Empowerment, Wage Enforcement, the Office of Immigrant Affairs, and Foreclosure Prevention. More closely today, though, we're going to look at the Rent Stabilization Unit and the Foreclosure Prevention Unit. Next slide, please. Now, before we actually get into the topics that we're going to cover, I just want to let everyone know that we will be taking questions at the end of the presentation. If you have something that you heard or something that you want to talk about, you can keep your chat box open as it shows there. I would encourage you to write something down if you have a side piece of paper, and then bring it up towards the end of the presentation. Next slide. Okay, so today we're going to cover a few topics. They do sort of a lot of the information that's going to come during this presentation does cross with each other, but it's sort of the nature of the way that the laws were written. We are going to look at property owner protections. We're going to look at the Rent Stabilization Program, the LA County Eviction Moratorium, and some other specific legislative updates. Next slide. Okay, so within the County of Los Angeles and the Department of Consumer and Business Affairs, our unit exists called the Foreclosure Prevention Division. Now, the program is really listed and was really equipped to assist property owners of 15 units or less with exploring options to avoid foreclosure with their lenders when they're faced with either imminent foreclosure or they're actually beginning the process. The unit is in fact set up to help open a dialogue between property owners and lenders with the idea that the rules around federal and loan limits in each individual situation are respected and followed correctly. Now, with all the new legislative laws that have been put into place, it can be kind of difficult for an average property owner to navigate their way, especially with a financial hardship, but through that entire process, especially a financial hardship that's caused by the coronavirus. And technically right now, it's affecting so many people on so many different levels. The amount of individual situations varies so much. An additional benefit of the service that we offer by the department is that the service is absolutely free. Our unit within the department is set up to constantly keep up with the new and up-to-date information related to opportunities that property owners might be owed or afforded. A difficult part of going through a presentation like this, though, is trying to, like I mentioned earlier, trying to provide an overall blanket statement of information that would apply to everyone. Most of the information here is going to be pertinent to most people. It's going to apply to most property owners, but there's always those few circumstances that would make the opportunities that are available to them change, or maybe not be afforded to that direct individual. So this is why we sort of recommend every individual that has a question, eventually reach out to our office directly. Let us discuss the particulars of your own situation, and let us figure out what method or what path you should at least consider when faced with an issue. Next slide. So concerning the CARES Act and AB 3088, when we look at this, there with the relief from, let me go back. Most homeowners are technically protected under federal law from foreclosure, and this was established by the CARES Act and the FHFA. What that did was temporarily pause or reduce mortgage payments should a property owner be struggling financially. Now, originally, this protection was afforded to anybody who was who had their mortgage federally backed by either Fannie Mae, Freddie Mac, the Department of Housing and Urban Development, or FHA, the Veterans Affairs, or the USDA. These were the only original loans that were sort of given the automatic protection from anybody who said, I've been negatively affected by the coronavirus and I need help. Now, those protections were actually put into place and have been extended now currently through June 30th of 2021. Now, where AB 3088, what that actually did was address the sort of the hole that was left after only federally backed mortgages were protected. After that, there was a large population of people that did not have a mortgage backed by one of these GSEs. And what AB 3088 did was essentially apply those same protections when it comes to the idea of applying for a forbearance to these non-federally backed loans. Now, there are limitations, and we're going to sort of go over that in a second. Next slide. Now, when it came to non-federally backed loans, AB 3088 stated a few different rules that needed to come out when it came to the opportunity for somebody to apply for what's called a forbearance. Now, a forbearance is when your mortgage servicer or your lender allows you to essentially temporarily suspend or pause, or even sometimes slightly reduce your mortgage payments for a small amount of time while you get back on your feet. There was issues about the timing of when it came to somebody actually requesting a forbearance during the COVID pandemic, and we're going to go over that in a second. But what AB 3088 really does is gives a property owner who has a first lien that is not backed by a government-sponsored enterprise to apply for a forbearance with a little more, I guess you could say a little more exceptions, or it wouldn't necessarily be as easy as if you did have a government-sponsored loan, but it was possible. Now, who qualifies for these requests? So to qualify for it, you would have to obviously be a property owner. The loan that you were requesting assistance on would have to be in the first position. The property would have to be between 1 and 4 units. And one of a unique benefit of AB 3088 was that the property did not necessarily have to be owner occupied. So a landlord holding a property, maybe he lives in one area and he has another property that has, it's a duplex or maybe a triplex. He would still be able to, provided certain conditions, request a forbearance if he was experiencing financial hardship due to the coronavirus. Next slide, please. Now, before we move forward a little bit, it is important to kind of explain that a forbearance doesn't necessarily mean that just because for now you're getting a temporary pause or you're getting assistance on your payments, that it's never going to have to be paid back. There are typically with different loans, there are different options when a forbearance comes up. Normally, it's not going to come up in a lump sum payment. If, for example, you requested a forbearance in January and you were given 6 months, at the 6-month ending period, the lender is not going to ask you typically to pay it all back up front. Now, this comes from the rule that the lenders are going to have to, under AB 3088, have to comply with normal government-sponsored enterprise loans and their rules. But getting into that, the payback, we'll move forward in a second. So the first part of the bill talks about the idea of documentation. A property owner is going to have to prove that they were negatively affected by the COVID-19 virus. Now, the small difference between a government-sponsored loan and a non-government-sponsored loan would be that the government loans would just require a telephone call for somebody to say, I was negatively affected and I need help. Now, the non-government sponsored loans are asking for some sort of documentation, some sort of proof. In my experience, it hasn't been a high threshold in the calls or the cases that I've heard or that I've dealt with. It has just been a call. That doesn't mean that it's going to be the absolute rule, but that's just what I've seen. There is also going to be a proof of that the loan was in fact current as of February 1st of 2021. Now, it shouldn't be difficult for your lender to understand or find out if you're current, but if that does become an issue, that might be another document that you have to provide through usually a mortgage statement or something like that. Now, the timeline. So once a actual request for a forbearance is submitted, the lender has 21 days to deny you based on your submission request. Now, the denial does have to come with certain caveats. It has to say specifically why the request was denied. Now, it could be the request was denied because under their guidelines, you simply don't qualify. They don't maybe recognize that you had experienced a valid COVID-related hardship. Maybe you weren't current as of the February 1st deadline. Now, if they do send you that denial, though, the AB 3088 would require that they send you a detailed reason as to why you were denied, and give you a 5-day, and give you the actual specific ways on how to amend your request. So maybe you didn't cross some T's, or maybe you did dot some I's, maybe you missed a signature here. They have to be very specific as to why you were denied. Now, if during that time the property owner were to actually provide an appeal and give a response saying, okay, I made the mistake on this form or this document, here it is now. The lender would be required within 5 days to give you an answer back. If you had directly addressed the things that they addressed, then they're going to be required within 5 days to give you a response, which is a really quick turnaround. And I think the idea is that, I mean, if people are losing their houses or their jobs and they're in a financial hardship, the turnaround time is going to be, pretty critical. Another thing that I think is pretty beneficial going down. Actually, excuse me, can you go to the next slide? The post-forbearance options. So when a property owner is in forbearance, and maybe they're, for the last example that I used, in forbearance for 6 months, they go from January 1st to the end of June. Sometime before the forbearance is over, I believe the actual rule might be 2 or 3 weeks, but it's probably gonna be a lot longer than that. Before that forbearance is over, the lender is actually required to reach out to the property owner and discuss what's called post-forbearance options. Now, this could be running a request for mortgage assistance based on financials. This could be essentially an application as to how we're going to move forward. It could be a continuation of a forbearance, but essentially they're required to let a property owner know that when this is over, these will be the next steps. And in the past, that wasn't necessarily something that had to be done. That was really something put on the property owner to call their lender and discuss. Now that the lender's obligation is to reach out and discuss these options, it puts a property owner usually in a better situation because they're notified. Usually property owners are going to be, understanding of what's coming up, but they're going to be notified formally that something might be, what options might be ahead of them. And that even if there are no options, that at least gives a property owner the idea that they're in control now. They understand, with enough time, what options should be taken, what needs to be taken, what's in front of them. And that sort of puts them, I believe, at least in the driver's seat. Now, the loss mitigation options that they do discuss, when it is discussed, is supposed to be discussed in the typical language that is used when a property owner calls their lender. So if you have a Spanish speaker that always calls their lender and they speak to a representative in Spanish, that information is supposed to be afforded to them in Spanish. That goes with every other language, no matter what it is. Now, SB 91, although it is a complex document, it does have a portion in there that mentions that it would exactly extend the obligation of the lender to provide the written notification concerning the request for forbearance, like we've been talking about, not until September 1st, 2021. So that benefit has been extended a considerable amount of time, especially now that everybody's really just doing their best to get back on their feet. And, there's just so much uncertainty out there. Now, with that, can we go to the next slide? With that, I'm going to hand this over to my colleague, Scott Schroeder, and let him sort of expand on the rental and landlord side of SB 91 and a few other topics.
Okay, Sam, thank you for that. Good afternoon, everyone. My name is Scott Treader, and I'm a senior counselor in the Housing and Tenant Protections Division of the Department of Consumer and Business Affairs. What does our division do? Well, we support property owners, mobile homeowners, tenants, landlords who have questions or who want to discuss issues relating to the county's rent stabilization ordinance or the county's mobile home rent stabilization ordinance. Residents and property owners can also contact us for questions regarding the county's eviction moratorium. We have partnered with an agency, Stay Housed LA County, which provides legal assistance through local nonprofit legal agencies, legal aid type agencies, and we help folks that are facing evictions and who are facing lockouts from the sheriffs with the hope that we keep people off the streets and don't contribute any further to our homeless population. Next slide, please. So what is the county's eviction moratorium? You hear a lot about it, and there's a lot of confusion around it, and understandably so. We take a lot of calls from property owners that are trying to figure it out. So let me try and give you a little bit of an overview. So it is a county-wide ban on evictions for non-payment of rent for residential and commercial tenants that have been financially affected by COVID. Okay, so who's covered? This covers residential tenants in LA County. This covers commercial tenants in LA County. And it also covers mobile home space renters in LA County. The county's moratorium, the eviction moratorium, applies to unincorporated areas and incorporated cities within the county that do not have their own local protections in place. So if the property is in an incorporated city and that city has its own rules in place or its own eviction moratoriums in place, then those rules would supersede the county's. How long is the eviction moratorium in place? Well, the eviction moratorium was recently extended by the Board of Supervisors, and it was extended until June 30th, 2021. So what protections does the county's moratorium include for residential tenants? Well, right now, under the eviction moratorium, there's a prohibition on evictions of tenants for non-payment of rent, for late charges, and any other penalties or late fees, if the tenant can certify and attest to their inability to pay their rent right now because they've lost their job, they've been financially affected by COVID. As long as they do that, those protections are in place. If a tenant brings in an unauthorized occupant who's not on the lease, or a pet that was not previously living with the tenant, under previous rules, that could potentially be something that a tenant could be evicted for because they're violating their lease. But right now, there's a protection for people that are bringing in pets or unauthorized occupants. The same goes for a tenant creating a nuisance. There's also there's a no-fault eviction prohibition in place that says that if a landlord or property owner wants to do a substantial remodel or a demolition, that's currently not allowed. And then lastly, if a landlord serves a proper notice to a tenant, a written notice 24 hours ahead of time, under normal conditions, a landlord can then enter after 24 hours into the tenant's unit. However, because of the eviction moratorium, it currently states that if a tenant is not comfortable with a landlord coming in and doing whatever the landlord wants to do, then the tenant can deny the landlord entry. And again, before the eviction moratorium, if a tenant would deny a tenant or deny a landlord entry into the unit, that could be grounds for eviction. But right now we're saying no, because of COVID. If a tenant has a compromised immune system, or they have, older people that are living there that are sick, or, at risk, high risk folks, the tenant has the right to say no, unless it's an emergency where, a pipe burst, or, the place is on fire, something urgent where the landlord needs to get access to that unit immediately. That would be allowed, but otherwise, the tenant can't deny the landlord entry. Additional protections under the eviction moratorium include a rent freeze, but this rent freeze only applies to properties that fall under the county's rent stabilization ordinance. So the property has to be located in unincorporated LA County. The property has to have been built or first occupied on February 1st, 1995 or older, and it has to be more than one unit on a lot. So it has to be a duplex, triplex, or a multifamily unit. If it meets all those criteria, then that means the property falls under the county's rent control ordinance. And that means that there's currently a rent freeze that applies to those properties. In addition to the rent freeze, there's also anti-harassment provisions that are part of the eviction moratorium that say landlords can't harass their tenants right now and can't retaliate against tenants who flex their knowledge and assert their rights to the landlord and let the landlord know, hey, I have protections as a tenant. And if a landlord's not happy about that, sometimes that can lead to a harassment situation or a situation where a landlord wants to retaliate against the tenant. So switching gears a little bit, we're talking about commercial tenants under the eviction moratorium. And by commercial tenants, we mean folks that are like bars, restaurants, hair salons, nail salons, any small business like that where they're renting the space from a commercial landlord. Well, right now, there's a commercial eviction moratorium in place for commercial tenants as well. And what that says is similar to the residential eviction moratorium. It's the same for commercial tenants, that if they cannot pay their rent because their business has been shut down due to health and safety reasons from the pandemic, they are protected. They cannot be evicted. They cannot be charged late charges or any other fees or penalties if that tenant, that commercial tenant, can show evidence or attest to the fact that they've been financially affected by COVID. Additional protections are similar to what we just looked at for residential tenants. The landlords can engage in harassing behavior or conduct or try and intimidate their commercial tenants. So does this mean tenants do not have to pay rent? No, it does not. And there is a bit of a misunderstanding by some folks in LA County that think this is a vacation from rent. That's never what this was intended to be. It was meant to address the pandemic that we've been dealing with now for over a year, and it was meant to try and keep people in place. And it was never meant to say, no, you don't have to pay rent. It was only meant to be a deferment of the rent until a time when, in the future, conceivably that the tenant would go back to work, that, the job would come back or jobs would come back and they would start making an income again, and then hopefully have, the money to pay back the back rent that's owed. So what are the terms of the repayment for the back rent? And this is spelled out in Assembly Bill 3088, which Sam covered a portion of it I'm going to cover the portion that applies to residential tenants. And this is also in Senate Bill 91. What these bills say is that for the back rent owed for this period from March 4th, 2020 through September 30th, 2020, that money must be paid for the back rent by September 30th, 2021, okay? The back rent for the period October 1st through June 30th, 2021 is due as of August 31st, 2022. But I want to point out that as of June 30th, 2021, a tenant is obligated to pay at least 25% of the back rent that they owe by June 30th. If they don't do that, then potentially a landlord could move forward with an eviction for non-payment of rent. For commercial tenants, under the county's eviction moratorium, if it's less than 10 employees, that commercial tenant's going to have 12 months following the end of the moratorium. So that would be, if the moratorium does end on June 30th, 2021, which is what it's currently scheduled for, then that means that on June 30th, 2022, the commercial tenant would have to have paid back what they owe in their back rent, okay? Now for employees and companies that have 10 to 100 employees, they're given less time. They're only given 6 months to pay back what they owe at the end of the moratorium. So again, keeping with the current end date for the eviction moratorium, which is June 30th, that would mean that a commercial tenant that has 10 to 100 employees would have until December 30th to repay the back rent that is owed by that commercial tenant. So who's exempt from these protections? Large commercial tenants, large companies, publicly traded companies, companies that have more than 100 employees, companies that are multinational companies. We get calls from commercial tenants, and they call us. They're working in one location, but they will say that their company actually has a number of locations. And you know, would we count just the employees that are in the one location, or is it an aggregate amount that we would count all the employees at each of the location for purposes of this commercial eviction moratorium? And the answer is that we would have to count the total number of employees that the company employs at that time. So that's the answer to that. The exemptions also apply to airports effective September 1st, 2020. And this is a little bit tricky here, but under the county's eviction moratorium, for the period October 1, 2020 through June 30th, 2021, the county's eviction protections for non-payment of rent were superseded by the state law, that is Assembly Bill 3088 and SB 91. So for that period, the county's eviction moratorium for non-payment of rent only was superseded by these two state laws. So on February 23rd, the Board of Supervisors held a meeting, and they voted to extend the eviction moratorium to June 30th, 2021, which we've already covered, to the extent that the protections are not preempted by AB 3088 and SB 91. And that's exactly what I was just talking about, where the eviction for non-payment of rent, those protections went away from the county and went up to the state eviction moratoriums. This also included administrative fines and penalties that the county put into place for violations of the moratorium. So basically, the Board of Supervisors added some teeth and some monetary penalties that can be assessed against folks that are violating the terms of the eviction moratorium. One side note, so for folks that have properties in unincorporated LA County who will be required to register their properties this year with the county, because our rent stabilization ordinance is relatively new, and we're just getting to the point where now we're starting to register properties. Well, what the Board of Supervisors said is property owners in unincorporated LA County, if you register by September 30th, 2021, we will waive the fees, the registration fees that are normally assessed when you register each year. And we get a lot of questions from property owners that want to know how to go about registering. We are in the process. We have been delayed. This should have happened already, but because of COVID and other priorities, we haven't been able to stick to our original timeline. So more information will be coming and will be sent out to property owners regarding registering their units that are in unincorporated LA County, but nothing is required at this time and nothing has been sent out at this time. So we just ask property owners to be patient and sit tight, and we will be providing that information for sure to homeowners probably over the summer. Okay, so we've kind of covered these two laws already. The way to think about them is they're essentially identical laws. The only difference, the main difference, is that AB 3088, as far as time periods go, it applies to a certain time period. So it applies to the dates we see here, September 1st, 2020 through January 31st, 2021. And again, it does provides protections for non-payment of rent for tenants who have been financially affected by COVID, okay? But the tenant has certain obligations to get these protections. And one of the obligations that I mentioned before is that the tenant has to pay 25% of the rent that they owe by June 30th, 2021. But the other obligation that the tenant has for this period up here and for the period SB 91 is that the tenant needs to provide the landlord with a copy of the declaration of hardship for each month that that tenant cannot pay their rent because they've been financially affected by COVID. This declaration form, it's a very simple form, and it's essentially just an attestation by the tenant to the landlord under penalty of perjury under California law that the tenant is saying to the landlord, I've been financially affected by COVID, my company shut down, my restaurant shut down, I don't have income, that's why I can't pay you rent. And as long as the tenant does that under these two laws, then the landlord can't go forward with an eviction action. Also, I wanted to mention that under SB 91, there's also a component that we'll talk about here in a minute that has to do with rental assistance. And I know a lot of folks are interested in what kind of rental assistance is available, both property owners and tenants. So we'll touch on that in a minute. So again, we kind of covered this already where the evictions for non-payment of rent due to COVID, financial hardship have been lifted out of the county's eviction moratorium, and they look to the state AB 3888 and SB 91's eviction moratoriums, okay? So just that piece got lifted out of the county's eviction moratorium. Now, I just mentioned this, that tenants are obligated to provide that signed declaration to the landlord for each month that the tenant cannot pay the rent. And then all other local county protections remain in place for the rest of LA County. So that means all the other things that we just talked about as part of the county's eviction moratorium, those are still relevant and still applicable. Commercial tenancies, AB 3088 and SB 91 do not deal with commercial tenancies at all. So there is no impact whatsoever by these laws on the county's commercial eviction protections. So when does the rent have to be paid back? So we have these two periods here. Again, this March 4th, 2020 to September 30th, 2020. The tenant has until September 30th 2021 to repay the back rent that's owed for this period. So that's an important distinction to make, that come September 30th, 2021, if the tenant doesn't pay back what they owe, then conceivably come October 1st, the landlord could evict the tenant or sue this tenant in small claims for non-payment of rent. For the period September 1st, 2020 through June 30th, 2021, it's an extension of the same protections, with the obligation on the tenant that they have to pay that 25% of the unpaid rent by June 30th, 2021, and they can either do that in one lump sum, or they can choose to pay 25% of the rent that they owe for each month during this period. So it's really up to the tenant how they want to pay it, but it's either 25% each month that they have to pay, or an aggregate of 25% that would be paid as of June 30th. And then for repayment for the balance, for the other 75%, would have to be paid by August 31st, 2022, okay? So now it looks like we're going to cover some of the resources that are available to property owners, to business owners. The county established the Disaster Help Center. They provide various support and help for small landlords, small businesses, potentially property owners. And we've launched this during COVID, and the program seems to be working out pretty well. So here's the big thing that a lot of people are interested in, and this is the rent relief program. The federal government, through one of the last stimulus packages, allocated $2.6 billion to the state of California to devote to helping people with rent that is owed. And under this rent relief program, which launched, by the way, March 15th, so it just launched this month, and this is a state program, the county has decided not to offer its own rental assistance, but rather to defer to the state program. So any tenant or landlord that wants to apply for assistance through that program, they have to apply through the state. And we have their contact information here at the bottom. You can go to their website, housingiskey.com, or you can call that phone number. But basically, under this program, if a landlord decides to participate in it, the landlord would be eligible potentially for up to 80% of the back rent that is owed to that landlord through this fund, okay? But one catch, and some landlords may not be good with it, some may, but the landlord must accept to forgive 20% of the back rent that is owed through this program. So if a landlord's willing to forgive 20% of the back rent in order to get 80% of the rent that is owed to him or her, then, and if they qualify for the program, then they will get paid through the funds in this program. So that's how it works. If a landlord decides, hey, I don't want to participate, I don't want to forgive 20% of the debt, that's fine too. So what would happen in that case is, if the tenant is still eligible, then the landlord will still receive 25% of the back rent that is owed by that tenant as a direct payment from this fund. So that's why we're pretty excited about this. It's a pretty significant amount of money. It's probably a drop in the bucket compared to how much back rent is owed, but it's a step in the right direction, and we're encouraged that it's finally considering landlords and property owners, their stake in the game, and the fact that they need help, because there's two components to a landlord-tenant relationship, and you got to look out for the landlords as well. And this program tries to address that by providing direct rental assistance to property owners and landlords. And then the Board of Supervisors also recently approved a mortgage relief program. And this has been provided to help small landlords, what we call mom and pop landlords, with some kind of financial relief if they've been affected by COVID. And we don't have a lot of the details yet. They're still being fleshed out, but we wanted to provide you with information that this is coming, this help is coming, and you would want to contact DCBA's foreclosure prevention program to find out more about this as more details become available and when the program actually opens up for applications to see what exactly the criteria are for eligibility to participate. And with that, I think that concludes our presentation, but we wanted to be sure and point out that this is the phone number for the rent stabilization program, for the housing and tenant protection program. We go by both names, but this is our counseling hotline number, the 833-223-RENT. We also have a dedicated email where we can respond to email inquiries as well. And then we also have foreclosure prevention's information on here of how to reach them. And then lastly, we also have the website for the rent control unit. It's rent.lacounty.gov. And then for foreclosure prevention, this is the website where you can access their information online. And with that, I will turn it over to Kevin, and then I guess we will conclude and then open it up for questions.
Right. So actually, we'll take this time right now to take questions. We had about quite a few of them in the chat box. So what I'll do is I'll just go ahead and read them off, and I'll let one of the presenters answer the questions. So the first one we have is, what will happen when your forbearance ends? Will your balance accrued during forbearance be due immediately? They also want to know if they could refinance or add the balance to the existing loan. What can they do?
Okay, Clem, so that's actually a good question. I think a lot of people want to know. So the rule is right now is that when you're getting near the end of your forbearance, the lender is required to actually reach out to you and discuss the options that might be available to you to get back into normal servicing. Now, normal servicing is you making your normal monthly payments with all the arrears that might have been accrued through your forbearance gone. Most lenders are not going to this is the information that we received now, but most lenders are not going to require an immediate balloon payment. Now, either way, if near the end of your forbearance, you have that conversation with your lender, it's already been encouraged by the CFPB to reach out to the lender and say, okay, I understand this is what you presented me. What else is available? A loan modification might be available. A balloon payment at the end of the loan might be available. And that's a good idea to think ahead. A refinance might be something you want to do. A partial claim or a repayment plan. There's a lot of options. But what I think everybody's recommending right now is, if you are presented with that single option, to sort of explore if there's anything else and why not. That's I think that's really the best idea there.
Okay, thank you, Sam. Next question. Do these rent provisions apply to storage units, and I guess particularly storage units in the city of Los Angeles?
Okay, so if the storage unit is in the city of Los Angeles in their jurisdiction, which we'd have to confirm, then yes, there are protections for those folks that are renting those storage units in the city. For the county, in unincorporated LA County, there are also some protections in place for storage unit renters, but the storage unit for the county has to be used for a commercial purpose in order for those protections to apply.
All right, next question. Will the moratorium be extended or not known yet? And I guess it could be an answer from both. Well, so the first one would probably be foreclosure and the other ones would be evictions.
So as far as we know right now, the deadline for the foreclosure moratorium is June 30th. in the past, it has gotten, I want to say maybe a week or two before the deadline, and then new legislation has come out to extend the moratorium. So, I mean, unfortunately, it's going to be sort of one of those things that we have to wait and see. It is around a couple months away, but you know, I mean, we don't know yet.
Yeah, and not just add that, yeah, it's just hard for us to know because, as we were saying earlier, we're still in very uncertain territory. We don't know how the business recovery is going to go. We're just starting to get into the lower tiers of the health and safety recommendations where the businesses are starting to slowly reopen. So it's kind of hard to say what things are going to look like in June. You know, we are still a few months off, but you know, if it looks like the need is there and if these protections need to continue, then our state legislators will make that call, and same at the local level for the county board of supervisors. So they'll really have to make an assessment as to where things stand as we get closer to June to determine whether or not these protections need to be extended or not.
Next question. If the back rent is not paid by September 30th, 2021, will the landlord be able to start the eviction process?
And the answer to that is maybe. It depends on if the tenant has provided certification or declaration up to that point, but they just haven't paid the 25%, then the landlord is probably going to have to sue in small claims court. The landlord might not be allowed to evict. The landlord might only be able to recover the monies that is owed for that back rent. But we would certainly refer any property owner that has that situation to an attorney so that they can discuss the individual circumstances, because the devil's in the details. You know, it really depends on specifics, and you know, that would determine whether or not they could actually go forward with an eviction.
Okay, so we had a participant ask for the COVID-19 rent relief program information. So Kevin, if we could go back to that slide, or maybe, yeah, that would probably be good. So it's housingiskey.com, or you could call 833-430-2122. Okay, so next question, is the rent relief program, or I guess, does the rent relief program apply to commercial landlords?
No, and that's a great question, but this is only applicable to residential tenancies, not commercial. There's nothing in the state eviction moratorium that applies to commercial tenants at all.
Okay, so there's a question related to mortgages. Here it states, as a homeowner, we are held accountable for late fee added on to our monthly mortgage payment. Can it be waived? Is that something that is covered under this moratorium?
Going back, so I think it depends on the type of loan that you have, and I would have to double check, but I want to say that the GSEs were not charging late fees. I know they weren't reporting certain back payments to the credit agency, but that would be a good question. I would say you give us a call, and then you know, we can talk about the type of loan you have, and at least, I mean, have a conversation with your lender and find out what their specific position is.
Okay. Okay, so what about mortgage relief for homeowners who are not landlords, who are living in the property as their own home? The federal government earmarked millions of relief for mortgage relief. Do we apply at Fed, state, or local level?
So the actual county program that we had mentioned in the earlier, I believe, is going to be you know, it's going to be open to people who are in fact just property owners. And Clemente, correct me if I'm wrong, but I'm almost sure that's where that program is geared towards. Now, currently, that program is still being worked out through policy or maybe some other form of deciding how the funds are going to be dispersed. So that's why we sort of recommend that you at least give us a call or send us an email to the contact email that we had sent, homehelp@dcba.lacounty.gov, and give us your name, your telephone number, your address, and the reason why that you're inquiring. And once we've been instructed to collect that information. Once it's available, the information should be dispersed back. Now, I don't necessarily know that you emailing us secures your spot in line necessarily, but those are the instructions, and I think you might benefit more than if you don't send us any sort of email.
Right, and I just also want to mention that we heard President Biden sign the new COVID relief package, and I think with that there was some mortgage relief in that new bill that has yet to be dispersed to the states. But our understanding is that money will be administered by the CalHFA. So that's also going to be administered through the state. So in addition to the county mortgage relief program, there's going to be federal money available through the state, and that would be administered by CalHFA. Sorry about that. Okay. Let me see if there's any more questions. Okay. Okay, so there's a question about refinancing. And if you're not current, how can a refinance be possible if you're still unemployed?
I think the question is there. It's probably not possible. A refinance is going to be a whole new loan that you're going to run through, usually through at least a legitimate lender is going to want to run your credit. They're going to want to check your income. They're going to want to check, your tax return. They're going to want to verify that the income comes in. They're going to want to look at your debt. A refinance at that point is probably not the best option. So exploring other options like a continual forbearance, or maybe a loan mod, reducing your payments, or maybe putting some portion of the loan on the back end as a payment. That's going to be something you're going to have to explore. But that's really going to come around the time after or right around when your forbearance is over, or if you're denied, then what other options for mortgage relief at that time would be available.
Yeah, and just to expand on that, if you have a GSE loan or another loan that's backed by the federal government, and you got on a forbearance plan prior to defaulting on any payments, then that should not impact your credit report. So that was a protection that was offered through the CARES Act. So if you were given, let's just say, a 9-month forbearance plan, and when you started the forbearance plan, you were still current with your payments, then you should be okay if you want to come out of that forbearance plan and look into doing a refinance. Now, the assumption is that the financial hardship has been cured within that period. So it's still possible, but there's just nuances to that. Okay. So another question, can a landlord recover back rent from a veteran Section 8 renter who abandoned the unit December 1st, 2020?
Without more detail, that's kind of a difficult question to answer, but the bottom line is the landlord would have to try and recover the monies by lawsuit, most likely, and would have to get a money judgment against that former tenant. Even though there's Section 8, that really shouldn't matter, but that might add a wrinkle to it as well. So that would certainly be something you would want to talk to an attorney about to see what your legal options are for recovering that back rent.
Yes, and participating in Section 8, I know through the county there is a caseworker, so you may also want to reach out to the caseworker in I think it's the housing authority, and inquire about that. Okay, so there was a question about defining tenants, and this person wants to know if a paying renter who had a written lease or rental agreement at one time.
Yeah, I think I know what that question means, and we've gotten this question before. So it's pretty common for people to start their leases or their tenancies, I should say, with a written lease. But what often happens is then, that initial lease expires, and then the tenant goes on a month-to-month basis at that point. So I think the question is, would these protections still apply even though the year-long lease is not in effect, but a month-to-month tenancy is still in effect? And the answer is yes. There's no distinction between the month-to-month tenancy versus someone who has a written lease in place for a year or more. Those same protections apply in either case.
All right, Kevin, I'm going to throw a curveball at you. So how about a situation where it's a lodger or maybe a guest that outlasted their welcome?
Did you just throw that question to Kevin?
Sorry, I meant Scott. Sorry.
I was going to wait for Kevin to answer that, but I'm sorry, the protections, do they apply to lodgers? Was that the question?
Yes.
Yeah, the answer is probably. Again, first it would have to be determined what the legal status is of the tenancy. Is it a lodging situation? Are they sharing common areas with the property owner in the house? Does that include the kitchen and the bathroom? There's a lot of questions that would have to be asked to determine exactly what rights that person would have and what kind of tenancy they have. And we would most likely recommend that they speak to an attorney to get clarification on what their legal status is and to determine what protections do or don't apply to them.
Okay. Thank you. So next question, are there any kind of evictions being allowed currently? In other words, tenant at will?
Well, tenant at will is essentially, I think, any tenancy. So yeah, the answer is it depends. It depends on what kind of eviction you're talking about. It depends on a number of factors. And without being able to examine those factors and without being an attorney, I can't give a legal opinion, even if I had those details. So that's something, again, that a person would have to talk to an attorney about, because yes, evictions are happening. There are just certain restrictions on certain types of evictions. So it depends on what the eviction is for. And, that would have to be discussed with an attorney.
I just want to add to that. When it comes to evictions for property owners, so for instance, I was living in the home, the foreclosure went through, and now the new owner or the bank is trying to gain possession of the property. So the CARES Act states that if you're covered under one of the federally backed loans, then that eviction is being held. However, there are other types of foreclosures that are not covered under this. So for instance, if you live in a condominium or a I guess in a complex that has an HOA, HOA can move forward with the foreclosure, and you could be evicted from the unit. Also, if the foreclosure was due to a junior lien, so a second loan or a third loan, whatever the case may be, then yes, they can move forward with the foreclosure and the eviction. So actually, we'll be covering that specific topic on our next webinar. So that'll be in about 2 weeks. So look out for information on how to register for that one. See, there's a couple more questions. I think we're at 3 o'clock, but I think we could get these in really quick. Does the rent relief program also help seniors who are receiving Social Security and have not been able to pay their rent?
Well, the state is administering the rent relief program, so that would be a question for the state. And for the Housing is Key, the information that we provided, the phone number. But if the senior is a tenant and they meet the income requirements of the program, then yes, they could potentially qualify, no matter what their source of income is. But they would have to meet the requirements of the program. And we're not administering the program through the county, so we don't have that level of detail that we can tell you. But from our understanding, if you're a tenant and you've been financially affected by COVID and you meet the income and eligibility requirements of this program, then yes, you probably can get help.
Okay, and I think that's all the time we have for questions. If there's any other questions, you could go ahead and either submit them through the rent@dcba.lacounty.gov, or if you have a question that's related to mortgages or foreclosures, you could email those to homehelp@dcba.lacounty.gov. Okay, so thank Sam and Scott. And if you or someone you know is facing foreclosure or an eviction, the DCBA is here to help. Our services are free, confidential, and our well-trained staff can work with you to explore all your options. Thank you and have a good evening.